Welcome to the class. In this first lecture, we're going to look at fundamentals of the law. We're going to break the law down and talk about its component parts. And we'll also spend some time talking about why it is that we study the law in business school. So we start with the notion of the law is essentially the rules to the game. So when you think about the law, it's like when you open a box of Monopoly and you take out that instruction sheet. And it's the rules to the game. And that's essentially what the law is. And so you would not want to play a game without knowing the rules. So doing business today requires you to know the rules. Now these rules are not as simple as looking at a Monopoly sheet. The rules can be difficult to find and to interpret. You as future business managers, can you use your knowledge of the rules to achieve competitive advantage? So in this lecture, we're going to look at the fundamentals of the law, and we're going to discuss how a business manager can use these rules to achieve a competitive advantage over others in the same industry. So first we have to look at the question of what is the law? How do we define the law? What is the law doing? What's the role of the law? And we start with this idea of the law provides a framework for society. Now, how many of you have ever watched a house being built from scratch? What you will notice is, first of all, they lay the foundation, prepare for the house, and then they frame it. Now, the framing is comprised of 2x4s, lumber, unfinished, unpolished lumber. That framework, however, is going to be hidden at the completion of the house. The house will be covered with brick or stone or some other material. But in fact, it's not the brick or the stone that is holding the house up. Instead, it is that framework which has now been hidden in the walls. And so that's what it is with the law. Law is the structure on which society hangs. Everything hangs off of the law. Now the reason we need the law, especially in business, is the law provides stability and predictability and continuity. And it helps managers to plan. It helps people to plan their lives. And that's why we need a stable body of law to allow for the ability to make future plans. Now, when we talk about the law, another aspect that we need to discuss is the law is actually made up of two elements. In every law, there are these two elements, starting with the rule. There is a rule that forbids something or requires something along those lines. There's a rule in place. That's the rules to the game. But there's another second aspect to the law that is important, and that is it provides the means to enforce the rule. Now in this class, especially in the first module, we're going to spend a lot of time talking about enforcement of the law, because the ability to enforce the law is what gives the law meaning. The ability to enforce the law gives meaning to the rule. It allows for a sanction to be applied if someone does not follow the rule. Now, what is the law doing? The law governs relationships. It governs relationships between the state and individuals. So when you look at a body of law like criminal law, for instance, criminal law is about addressing the relationship between individuals and society as a whole. which we are referring to as the state, and state in the biggest, broadest sense of the world. But essentially, it is the rules that apply between an individual and society as a whole. If you have ever seen a TV show or a movie about the law, and especially criminal matters, you will often see them refer to the case, this style of the case, as the state of Oklahoma versus John Smith, or the people of New York versus Jane Doe. That's because when a person commits a crime, they are violating the rule about interaction with society. Now, the second aspect of the law, the second type of relationship it governs, is the relationships between individuals, such that there are rules, for instance, for contract making and contract enforcement, private business affairs, nevertheless, that are governed by these laws. Now, what does the law do? The law is creating duties and obligations and rights that reflect accepted views of a given society. So, essentially, what we're looking at when we're talking about the law is it is the behavior that society has deemed acceptable, and that if you act outside of that ambit, of that scope, then in fact the law has been broken. So the law represents a body of rules, and those rules could be for action or conduct, is prescribed by a controlling authority, meaning some sovereign, whether that is the federal government of the United States of America, the state of Oklahoma, the city of Stillwater, the county of Payne. And there is some controlling authority who has issued this set of rules, and these rules have legal binding force, meaning you are required to follow those rules. And if you don't follow the rules, the law provides a mechanism to resolve disputes arising from duties and rights, and to allow the parties to enforce a promise in a court of law. We'll be talking a lot about enforceability in this class, and enforceability is a very strong concept, because what enforceability means is that if you and I have a contract and you violate the contract, you promise to sell me your computer for $500 next Tuesday, and next Tuesday arrives and you don't follow through on your promise. I can now, because of the rule of enforceability, I can now turn to the state of Oklahoma. I can file a lawsuit in the Payne County Court of Law, and I can sue you. And what I can do is ask the government to force you to keep your promise, or to pay me what it cost me because you did not keep your promise. So I can turn to the power of the state to intervene in our private contractual agreement. And so when we talk about enforceability, you remember that it's a very strong, a very important concept. Now, the law can be set down in a written code, and usually is. However, as we will discuss when we reach the common law, the law can also take a form that is made up of judicial decisions, what a court has decided. When an appellate court decides a dispute, it is actually creating a law, and that law is binding on everyone within the jurisdiction of that court. The law can be classified in different ways, and there is a chart in your book that sets this out to talk about the different ways of categorizing the law. There is no one set taxonomy of the law. Instead, we can think of it in different ways. And we can also talk about the purpose, how a body of law, such as criminal law, has a purpose, and would be the protection of society. Remember, criminal law governs the relationships between an individual and society as a whole. And examples of that are things like homicide or robbery or theft. There is a category of the law called civil law, and civil law is essentially about the relationships between individuals. And civil law is meant to compensate parties for loss or damage that occurs because of the failure of one party to follow the law. And so we have rules that cover things like negligence. If you get in a car wreck and you are injured, the law can require the party who committed the wrongful act, which is to say the one striking you with their car, to pay you compensation for your losses, for your injuries that you've suffered. Another aspect of the law that we talk about is substantive versus procedural. Substantive is the rules. Whenever we talk about substantive law, we're referring to these are the rules that the law is, that make up the law. Whether it's a state law or a federal law. When we are talking about procedural law, we are talking about the means to enforce the rule. So when I said we're going to be spending a lot of time talking about the means, we're going to focus initially on the procedural aspects of the law. And the reason why this is so important, and the reason why we do it, is that these procedural aspects can be so important that they can affect the substance of the law. And then finally, the last comparison we have here is public and private. Public would be the law that is established by a governmental entity. Private law refers to the laws that we create for ourselves. They arise from private agreements, such as contracts. A contract will set out the rights and the obligations of the parties to the contract. So there's a lot of different ways to talk about categories of the law. So you might want to check that out. Spend a little time looking at that chart in your book. Talk a little bit about functions of the law. Law provides for a system of order that defines rules of conduct and levies punishment for violation of those rules. Once again, we see the substantive and procedural aspects of the law. And what the law is doing is it ensures consistency and fairness in order to promote equality and justice in society. Now, why is the law important for business? In business, the law promotes good faith dealing among merchants and consumers. When you go to the convenience store and you buy a bag of chips and then you take the chips out of the store and you realize that the bag was open and the chips are stale, we know that we have rules that will protect us from those situations. There's a rule that requires anyone selling an item to make sure that the item is of at least average quality. Well, that's what the law does. It promotes good faith dealing. It encourages people to buy things like a bag of chips because we recognize that there is a rule somewhere that is making that merchant, that convenience store, stand by its products that it's doing. So it encourages us to engage in good faith dealing. When you contract to buy a car, well, when you are entering into that contract, you understand that if one person violates that contract, you are going to have a means of recovery for your losses or your damages that you've suffered. The law also provides reliability for business planning. And once again, we'll get back to this idea of business planning being important because it gives us a solid structure on which to build our businesses if we know what the law is. And that's why it's always very odd when the law suddenly changes, because it means that all of those plans that were made on the basis of what the law is, they suddenly are thrown away. So what we want to do when it comes time to think about the law is recognizing the need for a stable body of law to provide reliability for business planning. Let's talk about sources of the law. Every law must have a source. And in our system, a law could have one of many different sources. So we need to talk a little bit about where does the law come from. And we start with essentially the Constitution, constitutional law, because the Constitution is the foundational aspect of the law. We also then turn to statutory law. Statutory law is the law, the statutes that are passed and enacted and signed into law by the legislative body. So Congress of the United States or the state of Oklahoma legislature. They produce statutory law. Another law, and you probably have heard this term before, is the common law. And as we will talk about, the common law derives from judicial decisions, judges who are essentially deciding a dispute, but also making law. And then finally, administrative law. Administrative law comes out of the numerous executive agencies that are intended to provide guidance for the enforcement of the law. So, for instance, anti-discrimination laws, which we will take up studying in the last module of the course, those are administered by the Equal Employment Opportunity Commission. The EEOC is an appointed body that is part of the executive branch, but the rules that the EEOC publishes, while not being the law per se, are still important. So, administrative law. Let's talk about each of these in a little bit more detail, starting with the Constitution. Now, the Constitution is the foundation for other law in the United States. It is the Constitution that creates the Congress and enables them to have the power to pass statutes. It is the Constitution that provides for a judicial system that will essentially make law, make the common law. And so the Constitution is really the foundation for all law in the United States. And the Constitution is the supreme law of the land. There is no law higher than the Constitution. And how do we know that? Because the Constitution says so in what is known as the Supremacy Clause, which says there is no law above the Constitution. So it is the highest form of law in the land. Now, it functions with other laws to establish a structure for the federal and the state governments, and also sets out rules for amending the Constitution. If you want to change the Constitution, you can do so. You simply have to follow the rules that are set out in the Constitution. It also grants specific powers for the different branches of the government. So Congress has certain powers, according to the Constitution. The President of the United States and the executive branch has powers according to the Constitution, and the judicial branch, the federal court system, has powers that are derived from the Constitution. It also provides procedural protections for United States citizens from wrongful government actions. I'm sure you're familiar with the Bill of Rights, the first 10 amendments to the Constitution, which are all about protecting the people from abuse of power by the government. So the Bill of Rights are essentially an attempt to restrict the government, to restrict its powers. Statutory law. Statutory law is the law that is created by a legislative body, whether that is the Congress of the United States or the Oklahoma State Legislature or the Stillwater City Council or the Payne County Commissioners Court. Statutory law is created by a legislative body, and the U.S. Congress is the exclusive legislative body for the passage of federal law. A bill is a draft of a proposed federal statute. A bill is a first cut at what a law should be. A bill is a law that has not been passed or has not yet gone into effect. At the federal law, the president can sign a bill into law or veto it, and Congress can then override the veto with a 2/3 majority vote. These are basics from your civics class, and so hopefully you remember this a bit. Statutes at the local levels, again, we talk about the city of Stillwater, the Stillwater City Council. When they pass rules, they pass statutes, and we generally refer to those as ordinances. And these ordinances generally regulate issues such as zoning or imposing health and safety regulations. City ordinances are exclusive to the city. They don't have reach beyond the city limits. Now let's turn to the common law. The common law is the law made by the courts. And yes, courts do make law. Judges make law every day. Now, common law, what makes it unique is that it's based on a resolution of disputes between the parties. So when we cover the procedural aspects of the law, one of the most important aspects is this idea of procedure, the resolving of disputes, the means by which we resolve disputes. And so all of common law is based on the notion that two parties had a dispute, that a trial court heard the dispute, one of the parties appealed the judgment of the trial court to an appellate court, and then the appellate court is going to issue an opinion. It's going to issue its own judgment, and that opinion is going to have broader effect than simply applying to that original dispute. That opinion now will stand as the law for all subsequent cases that are similar in nature. So common law at its heart is law that's generated from resolving disputes. Resolution of disputes also set a specific standard for other courts to follow when a similar dispute arises again. So all courts that are subject to the jurisdiction of the court, the appellate court, must follow that original appellate court opinion unless it is overruled by a higher court. And this is the idea of precedent. Precedent is when courts apply the law of a previous case to current cases with similar facts. Let's talk a bit about administrative law. Administrative law is the source of law that authorizes the exercise of authority by the executive branch agencies as well as independent government agencies. Federal administrative law is that law that's authorized by statutes and by the Constitution, and it provides rules for applying the law. It's going to articulate rules, and those rules are going to be carried out by administrative agencies. One of the most important things administrative agencies do is to provide some guidance as to what the law means. Oftentimes statutes are drafted very broadly or very vaguely, and we don't know exactly what the law means until a federal agency provides some guidance as to what it means. And so this is the importance of these federal agencies, things like the EEOC. Administrative agencies have the power to administer the details of federal statutes and to have broad powers to impose regulations, to make policy, and enforce the law as long as it is within their designated area of jurisdiction. Now, much of American law is derived from English legal doctrines. So oftentimes we talk about Anglo-American justice or Anglo-American law, and what that is it is the law that was originally developed in England and which has been imported into the United States, oftentimes with changes or alterations, but in any event, it derives from these original English legal doctrines, and these doctrines remain true even for 21st century America, even though they may have been developed in 16th century England. Now, one of the most important legal doctrines that we have taken from the English is what's known as stare decisis. Stare decisis is a Latin phrase which means to stand on a decision. And the doctrine of stare decisis is the principle that similar cases with similar facts and issues should have the same judicial outcome. So the doctrine of stare decisis is what requires all lower courts to follow precedent, to follow the decisions of a higher court. When a case is heard by the Oklahoma Supreme Court, every court in Oklahoma must follow the rules that were set out in that Oklahoma Supreme Court case. And when the United States Supreme Court decides an issue, every court in the country must follow the precedent established by the court until such time as the Supreme Court reverses that precedent. So once an appellate court has decided a particular case, that decision becomes a precedent, which then is going to become the law for all practical purposes because of this doctrine of stare decisis. We also have legal doctrines related to remedies. A remedy is the sanction that a court can impose or the punishment that a court can impose for violation of the law. Now, in the English system, which we have incorporated into the American system, traditionally there was a divide between what's called legal remedies and equitable remedies. And what this meant originally was that if a case was brought in law, then the measure of damages was money, monetary damages. If a case is brought in equity, the remedy is an order by the court requiring something or forbidding something. And so these measures are known as remedies. Remedies at law generally take the form of money damages. And equitable relief, remedies at equity, consist of relief other than money, primarily things like injunctions. If your neighbor is building a fence and the fence has encroached on your yard, you don't have to wait for the fence to be finished to sue the neighbor. You can sue the neighbor and request an injunction from the court, equitable relief, that the court will not allow the fence to be built, or ordering what has been built of the fence to be removed. So a court has that sort of broad powers. Generally, we refer to this as injunctive relief, meaning an order of an injunction. So, in conclusion, what did we learn in this lecture? The law provides the framework for society. There are certain primary sources of the law. For your test, make sure you know these primary sources, know the aspects of them that we discussed and what your book discusses. I'm certain there will be questions on your test about that. And then keep in mind this idea that much of American law is derived from English legal doctrines, such as stare decisis. All right, that's it for this first lecture. I hope you enjoyed it. If you have any questions, please let me know. Otherwise, we will see you for the next one. Thanks.